Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. It is now over 8 months since Brian C. Kohberger stood up in open court on July 2nd, 2025, and changed his plea to guilty of the 5 very serious felonies he was charged with by operation of a secret grand jury indictment returned by the Idaho County Grand Jury in May of 2023. These were the counts that he was to stand trial for in the highly contentious, highly sealed case of Idaho versus Kohberger in August of 2025. On July 23rd, 2025, without any pre-sentencing procedures, Mr. Kohberger was sentenced, and he was sent to the Idaho State Department of Corrections, where he has been serving out his life terms ever since. Shortly thereafter, Judge Stephen J. Hippler announced that there would be a process by which he would be looking at documents under seal, and there are many in the case, starting from the end of the case and working backwards. And if you go to the Ada County Court's website, you will see a notification that documents will be released as they are approved. As of this time, only a few documents have been released to the public from the months of July, June, May, and April, and one from March of 2025. Absent those few documents, the rest of the case, backwards to its inception of December 29th, 2022, remains as sealed as it was during the pendency of this more than 2.5-year case, on top of which the many hearings that were held in secret, and on top of a gag order that was in place from day 4 of the case. A review of the docket this morning, Thursday, March 5th, 2026, reveals that with the exception of one document that was released last week concerning an in limine response with documents under seal addressing text messages of November 13th, 2022. None of the other dozens upon dozens of documents that Judge Hippler ordered to be unsealed to the public 2.5 months ago in a court order of December 18th, 2025, has been unsealed. They are still sealed from public disclosure. Moreover, there has been no court order initiating the process by which documents from 2024 would be considered for unsealing, as Judge Hippler did with the first, second, and third court order that went to the parties, the last of which was October of 2025. This process, for all intents and purposes, has come to a standstill. Might the only opportunity, we ask as a rhetorical question, for the public to finally find out what exactly happened in this case be in a possible appeal after the United States Supreme Court renders an opinion in Hunter versus U.S. dealing with the waiver of appellate rights defendants are required to sign as a condition of a plea bargain. The U.S. Supreme Court entertained a case that we have been telling you about, that we have a playlist on regarding court documents of Hunter v. U.S. on Tuesday, March 3rd, 2026. The justices appeared to be very interested in this case because it was only supposed to go for about an hour, and yet it went approximately an hour and 45 minutes. And we encourage you to listen to that oral argument, it's available on replay. I've provided a link to where you can listen to oral argument. And I encourage you to recall exactly what happened in the weeks leading up to a plea deal that came to the surprise of many, including myself. If you go to our community page on our sister YouTube channel, you will see the court order that Judge Hippler entered at the final pretrial conference approximately 5 weeks before jury selection was supposed to start on May 15th, 2025. A document and records hold order, and it states, based on sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to this case and the defendant, Brian Kohberger, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury. Ladies and gentlemen, due process is guaranteed by the United States Constitution, requires 3 basic things. One is notice when the government is seeking to take away one's property, liberty, or in a case like Idaho versus Kohberger, life, because it was a capital case. Secondly, an opportunity to be meaningfully heard. And third, the cornerstone, in my opinion, of our judicial process, a fair and impartial judge and jury. Shortly after Judge Hippler entered this document and records hold order, he refused to allow the adjournment of the jury trial. And then came the plea agreement, dated June 30th, 2025. Paragraph 6 has the appeal waiver that Hunter versus United States fundamentally deals with. It says here, quote, the defendant hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to Idaho Criminal Rule 35. I've provided a link to our community page where you can see that plea agreement along with the waiver of appellate rights. At Tuesday's hearing on Hunter versus United States, the justices of the Supreme Court had a lot of comments and a lot of questions for both sides. One was made by Justice Neil M. Gorsuch to the government's attorney, quote, if a district court says, I'm going to let an orangutan pick a sentence out of a hat, you would say there's no right to appeal that, end of quote. I encourage you to read Justice Jackson's paper that she wrote back in 1992 when she was a Harvard University student. This was her thesis entitled, quote, The Hand of Oppression, Plea Bargaining Process and the Coercion of Criminal Defendants, end of quote, where Justice Jackson asserted imbalances resulting in, quote, assembly line justice, end of quote, where defendants can be pressured into surrendering their constitutional rights. Amongst other matters, this paper discussed power imbalances between the government and a defendant and possible coercive aspects of plea bargaining. The ruling on Hunter versus United States is expected on or before the end of June 2026. The rhetorical question is asked, will any future appeal by Mr. Kohberger be the time that the public will finally learn what exactly happened? In that case, this will now conclude this episode of the Indie Zone. My name is Kathy. Thank you very much for joining us here today.